There's that old saying that if it looks like a duck, swims like a duck, and quacks like a duck, it's a duck. But what if, despite how it looks, swims, and quacks, the duck has papers that show that it never intended to be a duck? United States v. Leonard poses the duck question in the context of securities law. Specifically, should an investment's status as a security be based on how it acts or what it says it is? Paul Dickau and Nanci Silverstein were among 25 defendants who were charged with and convicted of criminal fraud in connection with their marketing of investments in film production companies. The defendants individually operated independent sales offices, or ISOs, that marketed and sold interests in several limited-liability corporations, or LLCs, that produced films. The defendants solicited investments in the entities via telephone and then mailed offering materials to potential investors. The offering materials included a brochure, operating and subscription agreements, an investment risk disclosure statement, and investment instructions. The materials represented that investors would actively manage the LLCs. However, in fact, the investors were given a very passive role in the entity's management. The investors rarely voted, weren't given an opportunity to negotiate the terms of the investment agreement, didn't accrue managerial rights until the LLCs were fully organized, and weren't required to have any film industry experience. Significantly, the materials didn't include accurate information about the commissions the ISOs would earn on the investments. Whenever Dickau and Silverstein sold an interest in an LLC, they received a sizable sales commission. Dickau's and Silverstein's combined commissions earned them more than $242,000. The defendants' failure to disclose the commissions they earned on their investment sales led the government to charge Dickau and Silverstein with securities and mail fraud. The jury convicted Dickau and Silverstein of all counts. Thereafter, Dickau and Silverstein appealed, asserting that they weren't required to disclose information about their sales commissions because the investments in the LLCs didn't constitute securities.